Good evening. On behalf of the Graduate School of Education, I'd like to welcome you all tonight to the Askwith Forum for an important conversation about race-conscious admissions in higher education. We are fortunate to have with us tonight two members of the Harvard faculty who have thought long and hard about this important question. And I know we'll benefit tremendously from the perspective they will offer us tonight. Our timing today is both ideal and, of course, hardly coincidental. As most of you know, the United States Supreme Court heard argument last Wednesday on Fisher versus Texas, a case that could remake the rules about how colleges and universities admit students and compose their student body. The question, as you know, is whether the University of Texas at Austin impermissibly considered race in composing at least a section of its admitted students at its flagship campus. Our panelists tonight will focus on the specific details of the Fisher case, but I'd at least like to underscore its importance, the importance of the decision to higher education and its potential significance. Most universities, including this one, believe firmly in the importance of student body diversity, both in what it offers educationally and in more generally advancing the institution's mission. This is reflected by the number of Friends of the Courts brief, amicus brief in legal terms, that have been filed by institutions of higher education, both in this case, in the Michigan case nearly a decade ago, and in the Boskey case that preceded it. I should note that Harvard has filed a brief in each of those three cases, and if you're interested in seeing our most current brief, please go to the General Counsel's website and you'll see a link to it. Regardless of outcome, this is going to be an important decision. At a minimum, it may provide guidance to colleges and universities, big and small, public and private, about what they may do. But more than that, it may potentially rework the rules and expectations under which most colleges and universities have relied for a good long time. Let me now introduce our two panelists. Lani Guinier is the Bennett Boskey Professor of Law at Harvard Law School. She received her BA from Radcliffe College and her JD from Yale Law School. During the Carter administration, she served in the Department of Justice's Civil Rights Division. In 1981, she joined the NAACP Legal Defense and Educational Fund, eventually becoming the head of its Voting Rights Project. She was nominated by President Bill Clinton in 1993 to be the Assistant Attorney General for Civil Rights. After serving on the faculty at the University of Pennsylvania for 10 years, she joined Harvard Law School in 1998, becoming the first African-American woman to be tenured in the school's history. She has written numerous books and articles on race, gender, civil rights, and affirmative action, including The Miner's Canary, Enlisting Race, Resisting Power, Transforming Democracy in 2002. And in 1994, she received the Rosa Parks Award from the Association for Affirmative Action. We are also fortunate to have with us tonight Tomiko Brown-Nagin. Like Professor Guinier, she is a professor at law at Harvard Law School. She is also affiliated with the History Department in Harvard University's Faculty of Arts and Sciences. She earned her Bachelor of Arts from Furman University, her Master's from Duke University, her JD from Yale University, and her PhD in U.S. Social, Political, and Legal History from Duke University. Before entering academia, she clerked for Judge Robert Carter of the U.S. District Court for the Southern District of New York, and subsequently for Jane Roth of the U.S. Court of Appeals for the Third Circuit. She also worked as a litigation associate at Paul Weiss, a leading New York law firm. Prior to joining the Harvard faculty, she held joint appointments in law and history at Washington University and at the University of Virginia. Professor Brown-Nagin is a leading expert on legal history, constitutional law, civil rights, and educational law, and has published extensively in those fields. Her most recent book, Courage to Dissent, Atlanta and the Long History of Civil Rights Movement, won the 2012 Bancroft Prize in American History. Please join me in welcoming Professors Guinier and Brown-Nagin to the Askwith Forum and thanking them for helping us to think about these very important issues.
Good evening to all of you. It's so wonderful to be here and to be invited to share with you our thoughts on the Fisher versus Texas case. I understand that the Students for Diversity, particularly two students, were instrumental in the invitation to Professor Guinier and I to come and share with you today, and we are very grateful for that invitation. Thank you for the introduction, and I hope that what I can do to begin the conversation is to place Fisher versus Texas in context to discuss the legal issues, Ms. Fisher's case, and also some interesting aspects of the oral argument that was heard in the Supreme Court last week. Now, the first question we might want to ask about affirmative action in 2012 is, why are we at this point again so soon? After Justice O'Connor's effort in 2003, when the justice was really considered the architect of a great compromise. She was said by many, of course, she was a former legislator, and she was said to have been, in many ways, a skilled politician in brokering a split decision in the University of Michigan cases, Gratz and Reuter versus Bollinger. What was that compromise? Well, in the Gratz case, the Supreme Court in split decisions decided that the university's policy looked too much like a quota, which we know is unconstitutional under Boskey. But the law school's policy in Reuter withstood scrutiny, and the court held that race could be a plus factor in a holistic admissions process. And as I said, she was hailed. One author said of Justice O'Connor that she had moved the court from obstacles to options, which is a Carol Gilligan-esque reference to the power of women decision makers. Well, that stroke of genius didn't last long, you would have to say, in thinking about where we are today. The national project of opening up leadership to all who are qualified is already up for grabs, and the question is why? Well, I would point to three considerations. First, his name is Justice Alito, Justice O'Connor's successor, who is to her right on issues of race, certainly. And then there are affirmative action absolutists on the court and in society. We have Justice Thomas, who, of course, is concerned about the stigma, as he sees it, of affirmative action to affirmative action beneficiaries. Justice Scalia, who is an absolute opponent of what he calls race preferences. And then there is the Chief Justice, who wrote in Parents Involved, the school desegregation case from a few years ago, that the way to stop discrimination on the basis of race is to stop discriminating on the basis of race, which has the virtue of being simple, I suppose. But third, we're here because of Justice O'Connor's opinion itself and the way in which it arguably left itself open to the sort of challenge that we are witnessing today in Fisher versus Texas. The first matter that is problematic in the opinion is the notion of critical mass, an ambiguous term that is open to challenge as being only about numbers, being only about quantitative considerations. The University of Texas would argue that critical mass also includes qualitative components, and yet the notion of mass really has led some justices to essentially say, show me the number. What is the number? Don't hide the ball. But of course, the precedents, as we can talk about during Q&A, suggest that it would be inappropriate for the University of Texas to indicate that it pursued a certain number of underrepresented students of color. The other aspect of Justice O'Connor's opinion for the court that I think is a bit problematic is that her notion of diversity is insufficiently tethered to a concept of social justice. And one could see this fairly clearly, I think, by considering the extent to which the Reuter opinion focuses not only on the judgment of educators, but on the viewpoints of, say, the military and Fortune 500 companies, which of course is valuable. But that aspect of the opinion, which looks outward, doesn't look inward, doesn't really talk about the value of affirmative action for beneficiaries themselves, but is outward looking, lends itself to the criticism that there is no limiting principle on affirmative action. So consider, what if in 20 years GM or GE or some other company decides that because of its business imperatives, it needs the racial makeup of universities to look different? What if it decides that it would prefer Africans instead of African Americans? Or that because of its business imperatives, it needs a certain other group, racial group or national group. There's nothing about the opinion, arguably, that actually speaks to why affirmative action is important from a social justice standpoint. So, for instance, there's very little discussion of historical injustice in the Reuter opinion or the Gratz opinion. And what Professor Guinier and I will discuss in part tonight is how the Fisher versus Texas case actually opens an opportunity to have that conversation about social justice, about fairness, and the role that affirmative action can play within that context. Now to a consideration of the policy itself that is at issue in Fisher versus Texas. It is a layered policy. One component is non-racial. It is a top 10% policy, a state law in Texas that holds that if a student graduates from a Texas high school in the top 10% of his or her class, he is admitted to UT. The other aspect, the other admissions pathway involves holistic review of applicants. One aspect of holistic review is may include a racial component. So not only test scores and grades, but may include a consideration of race. The argument here by Abigail Fisher is that it's that possible consideration of race that is unconstitutional. The holistic aspect that permits a consideration of race is unconstitutional. Further, the argument is that Texas had already achieved substantial diversity by way of the race-neutral pathway. And that is, to some extent, accurate. So after the passage of this top 10% law, I would say that the Asian presence at Texas increased significantly. The Latino presence increased measurably. The Black presence in the student body increased just a bit. And it's because, really, the African American presence in the population at Texas was still only at about 4.5% that UT, after Reuter, decided to reimpose the consideration in its holistic review of race, the potential consideration. Abigail Fisher, who was not admitted to UT despite being a legacy through the top 10% program and through holistic review, argues that it is a violation of the law to pursue that layered approach. the Supreme Court is considering this question of whether the layered, race-neutral, race-conscious approach in holistic review is unconstitutional. It's important to point out that Texas's layered approach is unique to Texas. There are states that use a top 10% or percentage program, automatic admissions program that is race neutral. There are no states, so far as I know, that, like Texas, have both types of programs. So in a way, Fisher is an odd vehicle for the court to use to reconsider affirmative action, to reconsider Reuter. Now, there is another dimension of the Fisher case that is important, another dimension of difference in Texas, as I mentioned before, and that is the question of history. Fisher versus Texas is the first case that the Supreme Court has heard that derives from facts in a southern state with an egregious history of racial discrimination. It makes Fisher different from Boskey, from Gratz and Reuter, from DeFunis, a California case from the 1970s. And so what Professor Guinier and I argue in an amicus brief that we submitted to the court on behalf of the Advancement Project is that there is a desegregation case for affirmative action at the University of Texas that can buttress the diversity case. And Professor Guinier will talk more about the details that we discuss, the historical facts that underlie our claim. The legal significance of the argument you should appreciate is that what we're arguing is that in Texas, we're not really considering a question of societal discrimination, which is the way in which the Supreme Court in the past, in many of these past cases that I mentioned, has understood our nation's history of racial discrimination and its present effects. The court has said that while the history is horrible, we can see that, but it really doesn't touch the present. I think in Texas, a different case can be made, and there is case law to support a remedial theory of the case in Texas. Now, moving on to the oral argument, which was interesting. It was revealing for obviously what is on the justices' minds, but also it raised questions that those of us who are interested, concerned about equity in higher education should think about. The first series of questions that I thought was really interesting came from Justice Roberts. Justice Roberts asked questions that I would classify as being about affirmative action fraud. So he asked the counsel for UT, what should happen? What would happen if a student, an applicant, is, say, 1/4 Hispanic? Should he check the Hispanic box? What if he's 1/8 Hispanic? Should he check the Hispanic box? And then he went on to ask, well, if he does, how would the university actually know or verify that that individual is in fact what he says? And the counsel responded that, well, as is true in any instance, the university accepts an individual's self-identification, which Chief Justice Roberts did not seem too satisfied with. Chief Justice Roberts, as well as Alito, also asked a series of questions about where Asian Americans fit into the affirmative action debate. And here the question is, well, partly it's this idea that the category of Asians is incoherent. So if the university is interested in diversity, it should be interested in actually knowing who the Asian Americans are in terms of nationality. You know, are they Cambodian, are they Korean, etc. The point that was made in the questioning, though, was also went to the idea that affirmative action is somehow illegitimate if it doesn't include Asian Americans. The response of the council there went to the idea that, well, Asian Americans aren't underrepresented. There was a lot of back and forth there. It's a really important question that advocates of diversity, the diversity rationale for affirmative action, I think have to answer, and it may well play a big part in how the court decides the case. A more important issue related to the question of diversity within diversity. And what do I mean by this? Well, Justice Kennedy, who of course is the swing vote in the case, propounded a series of questions along with Justice Alito to the Texas Council when UT argued that it really needed to attract a cross-section of African Americans, including African Americans who are the children of successful professionals. The idea is, from the perspective of UT, that it would like to have people in the classroom who bring different perspectives, different experiences. However, Justice Kennedy was really concerned that actually the UT's argument that it wanted to attract, in particular, blacks from professional backgrounds was no more than a concession that what it's really interested in is race. That this question really revealed that Texas is engaged in a kind of racial spoils system. This will be really important to the decision in the case, particularly for Justice Kennedy, I would say. There was a question or a proposition that was offered by Bert Rhyne, who is Fisher's attorney, that I also found very significant. Mr. Rhyne argued that in the future, universities should rely on class when they assemble, if they want to use affirmative action, which is a popular argument. However, in making that claim, Mr. Rhyne specifically said that he thought universities should not even permit or look to students' personal statements in considering whom to admit. And the question is, well, why is that? What's in the personal statements that is problematic from the perspective of opponents of affirmative action? And the answer, I believe, is, well, it's the idea that race really needs to be expunged from any consideration in the admissions process, that universities really shouldn't know, at least from the aspect of race and the social process, really shouldn't know anything about a student's background as it relates to race, which is quite a proposition insofar as it suggests that there should be a suppression of students' ability to express themselves. Now, I will conclude my comments by talking just a few minutes about the possible doctrinal outcomes here. So one possibility is that the court would overturn Reuter. I think it's a remote possibility. It's not something that Fisher's attorney is asking for. I think it's remote because I don't think that the Chief Justice, well, I think the Chief Justice is rightly concerned about the court's institutional integrity. We saw that with the Affordable Care Act case, I think I can say. And it would, I think, be viewed as reaching by many people to overturn Reuter outright. Another option is for the court to strike down the UT policy as insufficiently narrowly tailored, to conclude that where there is a race-neutral option, like the top 10% policy, there is no need, there is no interest to use a race-conscious element in holistic review. Now, it is possible that even if the court reaches this conclusion that, one, it wouldn't be that consequential because of what I've said about how the layered approach is unique to Texas. Well, it wouldn't be that inconsequential, I should say, outside of Texas. I know Texas is a big state, and you shouldn't mess with Texas, and I concede that point. But as to the way in which programs are shaped elsewhere, I'm saying that it wouldn't be that consequential, particularly if what stood afterwards was a sense that one could still use proxies for race and admissions, although, of course, a ruling cutting back on Reuter would obviously chill the environment for the use of consideration of race in admissions, no matter how, even if proxies were used. Another option is a tie. So there could be a 4-4 tie if Kennedy decided to join the three who are understood to be open to the use of affirmative action. Last week I was saying that I was betting on a tie. I was only betting, say, 50 cents, but now, after looking more closely at the transcripts, I'm actually skeptical that Kennedy would join the three. I think that this issue of diversity within diversity, of giving preferences to the children of black professionals has really caught the attention of Kennedy, and it could be deeply problematic. So we'll see what happens. I will conclude by saying that I think, and I know that my colleague shares this view, that affirmative action in higher education is really a long way from equity in higher education. And rather than spending so much time focusing on this issue, what we really need to talk about is how to achieve equity for the greatest number of students, which requires us to talk about K-12 education. There is an opening for doing that within the context of this case, in part because if what we end up having here is this race-neutral policy, it is criticized because some of the students, it's argued, are from weaker high schools. If that's true, of course, that's an indictment of the K-12 system. And so perhaps we can have that conversation. Professor Guinier will talk about other dimensions of true equality in education. Thank you.
So I want to talk about why Texas is different, and in particular focus on the emergence of a very large state that we now associate primarily with the West, although it started as a member of the Confederacy during during the Civil War. And as you can see from the campus map, there are monuments dedicated to those who served in the Confederacy. The particular monument that I would be interested in showing you, if this clicker works, yes, is one that was named after this gentleman right here. His name Colonel Simpkins, and I want to tell you a little bit about Mr. Simpkins. So Colonel Simpkins was a colonel in the Civil War, and when he left the Civil War, he decided he would organize with his brother a Ku Klux Klan effort in Florida, and he and his relatives were responsible for killing at least 25 free black men and causing all kinds of other trouble. And for that, he was then invited to the University of Texas in 1899 to become a law professor. This is a person who has committed criminal acts. He's now a law professor at the University of Texas, and he was a law professor at the University of Texas for 30 years, from 1899 to 1929. And during that period, he was invited every year to give an annual speech about his exploits as a Ku Klux Klan member to compel it to an audience that was very enthusiastic about what he had to say. Now, the reason he is a significant figure in this case is that it turned out in 1954, after the Supreme Court decided Brown versus Board of Education, that the University of Texas had a new dorm on its hands and was trying to decide whom they should name this new dorm after, and they agreed Colonel Simpkins was the perfect person to bear the name of this dorm, and so they created Simpkins Dormitory, which remained Simpkins Dormitory until 2010. Now, in addition to this picture of, see, there's Simpkins Dormitory, and then this is my favorite. This is a bust, a brass bust of Colonel Simpkins that sat in the law school library for many years, and the students were invited to come into the library. It sat at the reference desk, and they would rub their hands over the top of the brass bust for good luck when they were taking their law school exams. So Colonel Simpkins was associated with all kinds of positive things in the minds of many of the people at the University of Texas. Now, why is this particularly important? Well, as Tomiko suggested at the beginning of her talk, unlike Reuter, which was in Michigan, unlike DeFunis, which was in the state of Washington, unlike Boskey, which was in California, the Fisher case is in a southern state that was an active member of the Confederacy and that has yet to purge itself of all of that history. So that's why the monuments at the beginning become very significant, because those are not monuments that are put in the archives or in some other safe space in recognition of what they once meant. These are monuments that dot the campus, that if you are walking on campus, you pass these monuments every day en route to your classes. Now, it's not just about Colonel Simpkins and the monuments. It's also about the history of Texas in conjunction with its law-abidedness, or the opposite. So we have a series of Supreme Court cases, starting with Nixon versus Herndon and Nixon versus Condon. Nixon was a black doctor who wanted to vote, and he tried to vote in the Democratic Party primary, was not allowed, took the case up to the Supreme Court. The Supreme Court decided in his favor. And what was particularly important in terms of the Supreme Court's decision is what Oliver Wendell Holmes said in writing for a unanimous court. He said that Dr. Nixon's rights had in fact been violated under the 14th Amendment, speaking with the authority of a Civil War veteran, because Oliver Wendell Holmes was a participant in the Civil War on the side of the Union, and someone who had witnessed the passage of the Civil War amendments. Justice Holmes explained that Texas had, and I quote, directly and obviously infringe the 14th Amendment specifically drafted to protect Negroes, which is a really important idea when you're thinking now that the 14th Amendment may be used against the University of Texas to protect Abigail Fisher. When you look at the origin story, as some of our conservative justices insist we do as we're interpreting the law, that we have to be originalists. If we were to be originalists with the 14th Amendment, then according to Oliver Wendell Holmes, who was right there when the amendment was passed, that the Civil War amendments, including the 14th Amendment, were specifically drafted to protect Negroes. Though the amendment, he says, applies to all, it was nonetheless passed, as we know, and I quote, with a special intent to protect the blacks from discrimination against them, end quote. Despite the Supreme Court's mandate, however, in 1927, Texas refused to honor Dr. Nixon's right to participate. They just changed the rules. And so 5 years later, Dr. Nixon is back in the Supreme Court. This is now 1932. And again, he's alleging discrimination, and this time writing for the court is Justice Benjamin Cardozo, who once again emphasized that the 14th Amendment, and I quote, adopted as it was with special solicitude for the equal protection of members of the Negro race, lays a duty upon the court to level by its judgment these barriers of color. Now, I'm emphasizing the importance of people like Oliver Wendell Holmes and Justice Benjamin Cardozo suggesting that the 14th Amendment was specifically designed with a special solicitude for the equal protection of members of the Negro race. That is the law under which Abigail Fisher is challenging what the University of Texas is doing, and somehow the originalists on our Supreme Court seem to have forgotten about the original intent of the 14th Amendment as they are interpreting it now in 2012. Now, the cases involving Dr. Nixon were not the only cases in which Texas was brought to the bar of the Supreme Court. In fact, one of the most important cases involving racial discrimination was Sweatt v. Painter, and that was a case in 1946 where the University of Texas rejected Mr. Sweatt. He was a black graduate of Houston's Jack Yates High School and Northeast Texas Wiley College. He was a good and steady student who possessed, according to a historian, every essential qualification for admission except that of race, upon which ground alone his application was denied. That is a claim that Abigail Fisher cannot make, that her application was denied on the grounds of race alone. In fact, there's no evidence that her application was denied because of her race. None. UT excluded, when Heman Sweatt applied, the mild-mannered Sweatt, and every other person of African descent, no matter how virtuous at that time. This is now in the 1940s. In 1950, the Supreme Court forced UT to admit Sweatt to its School of Law and to admit other black applicants to the undergraduate college. In Sweatt v. Painter, this is 1950, the court held that UT could not exclude an otherwise qualified applicant on account of race, a holding that it reinforced in Brown v. Board of Education, which was in 1954, the landmark case barring racially restrictive admissions in public education. After the Supreme Court had mandated the desegregation of higher education, UT ended its open admissions policy. Very convenient change. In the past, UT had essentially admitted anyone who had a high school diploma to the university. After Brown, UT decided that it no longer needed an open admissions policy, and it imposed instead an enrollment restriction plan that required applicants to take standardized aptitude tests in segregated testing centers. So the black applicants who were applying to UT could not even take the test for UT in the same place as the white students who were then applying to UT. UT implemented the new policy after an official's analysis revealed it would heavily disfavor blacks. The testing requirement allowed UT to formally comply with Brown without compromising its racial integrity, And the other thing, of course, that's very important vis-a-vis the decision of Brown versus Board of Education is that it was within 5 weeks after that decision that the University of Texas decided to name its new dormitory after Colonel Simpkins, the gentleman who had started the Ku Klux Klan in Florida and with his brother had been responsible for killing at least 25 black people. Now, I don't want to emphasize simply the past or the history of UT in the early part of the 20th century. The point of all of that information is to suggest that the campus was fraught in terms of as a place for black students and Latino students to attend over the, I would say, 90% of the 20th century. So basically until the 1990s. And even today, the Daily Texan, which is the campus newspaper, still reports all kinds of assaults, physical as well as emotional, on the black and Latino students. In fact, in 2012, which is the year that we are presently living in, if we're talking about the past, it's also the present, one of the editors of the Daily Texan did a cartoon of Trayvon Martin that was considered very insulting by a number of the black students on the campus. It referred to Trayvon Martin as a colored boy, and there was some pushback against the Daily Texan for being so insensitive to the feelings and to the concerns of the students of color. That episode prompted the Daily Texan then to do an 8-part series on race as it is currently lived at the University of Texas. So we're not just looking to the past, we're now talking about something 2012. Abigail Fisher applied to the University of Texas 2008. So this is really contemporaneous. And in terms of people, students, black students, Latino students, talking about the experience of being at UT, they are still talking about the chilly climate on the campus. And I wanted to just read to you a couple of the students' comments regarding their ongoing sense of social isolation. And in particular, there is a young woman named Channing Holman who is currently enrolled at UT, and she vividly described the campus's racial climate in her guest column, and this is what she said. As, quote, one of the blacks that represent 4.5% of this university, I came to UT wide-eyed, in awe that I was where many students wanted to be, and I was so excited to begin a new chapter of my life. I knew UT was a predominantly white institution, especially based on the reactions I received from people in my hometown when I told them UT was my school of choice. In other words, her family and friends did not want her to go to UT because it had a reputation as not being a hospitable place for black students. This is contemporaneous, right? This is a young woman who was enrolled at UT in 2012. She says, but I refused to let it deter me from getting a UT education. Reality set in during orientation, when there was only one other black girl in my wing, and again when I was automatically labeled as an athlete because I was black. I have been the only black in a class of 100, and I have been stared at like I was on display in a museum, perhaps because I'm black. I've been overlooked during office hours because the white girl's question was more important, and I've been called the N-word while walking on Dean Keaton, which is a part of the campus, the first slide showing you all of the monuments to the Confederate soldiers. Now, black students are not alone in observing or experiencing this chilly environment for students of color on UT's campus. Latinos, for example, report being subjected to stereotypes and racial epithets. UT is still viewed as a campus that has not, quote, honestly dealt with its past and that still does not welcome blacks and Latinos. Many Latinos also feel isolated, according to Catherine Rodarte, a Latina currently in her junior year at UT. She says, quote, it's hard for me to speak up in class when it's almost all white students around me. This sense of social isolation is exacerbated by demeaning stereotypes that persist on UT's campus. For example, this is after the Trayvon Martin cartoon. In March of 2012, the Texas Student Publication Board censored the Daily Texan editor, Colby Angus Black, after he published articles that mocked 2 Latino students by name. Black lashed out against the students, one was named Oscar de la Torre and the other Tony Nelson Herrera, after they staged an on-campus demonstration in favor of diversity. Apparently that was just too much. Invoking age-old stereotypes, the paper published a cartoon depicting de la Torre, quote, on horseback wearing a sombrero and carrying a rifle. In 2012, the Daily Texan was compelled to address all of these issues in its 8-part series. And I would like to just read you one last comment, which was from a student, Zoya Waliani, a senior in the Arabic flagship program. She lamented a campus climate that gave rise to the racially tinged cartoon regarding Trayvon Martin, and noted the extent to which racism is present at UT, embedded in its landscape. Again, this is in 2012. We are not talking about ancient history. And she says, the years of racism ingrained in UT's landmarks and buildings, from buildings named for a KKK Grand Dragon to the 3 Confederate flags that fly on the 40 acres. There's, of course, RLM Hall, named for Robert Lee Moore, a mathematician who refused to let African American students in his class. Professor Moore would walk out of class if a black student showed up. This is a professor walking out of class because a black student showed up in his class, registered for his class. And of course, Painter Hall is named for the former UT president who defended the case involved in preventing Heman Sweatt, the black UT law applicant, from attending the school because of his race. So the point of giving you more and more and more information about both the past and then the way in which the past still defines the present is to suggest that what UT is trying to do with its holistic review is to change the present. Can't change the history, but it can do something about the present, and it acknowledges that without having a critical mass, as Tomiko referred to, or simply a sense of feeling welcome by Black and Latino students, UT will fail in its mission of educating the future leaders of Texas. 90% of the students who attend UT, or approximately 90%, are from Texas, and the school is a public university devoted to training future leaders. So it is not just to exorcise the past, but also to put the current students in a position where they feel comfortable and safe and capable of learning how to become leaders in a diverse society, particularly a society with the history that Texas has. So thank you very much, and now Tomiko and I are hoping you have lots of questions.
Try, if that's okay. So, Professor Guinier, I was watching you on C-SPAN a couple Saturday nights ago at the Century Foundation panel, where, well, I forget his name, but he was presenting all of his data and his recent findings. He was the opening speaker, and he was presenting his new paper. Yes. So I wonder if you'd say a few words about his report and what you think of it. And at one point on that panel, you started talking about the Canary and the coal mine and the mask. And I wonder if you'd say a few words about that as well, please.
Okay, sure. Is this mic on? Yes. Okay. So Rick Kallenberg is associated with something called the Century Foundation, and they are pushing class affirmative action rather than race affirmative action. And so this was a panel discussing that question with Ward Connerly and Rick Sanders and Richard Kallenberg, and then Debo Egedabali from the LDF. I have nothing against class-based affirmative action. I think it's actually a really good idea. On the other hand, I think that if we want to really deal with issues of race and class, then we have to do something very fundamental about the ways in which our universities measure merit among everybody. So that's the canary in the coal mines idea, that the experience of blacks or Latinos in terms of university admissions, the experience of women of all colors at law schools. I've had issues raised regarding women at Harvard Law School, women at the University of Pennsylvania Law School, that these are the canaries in the coal mine. And the metaphor is that before the miners were willing to use a gas mask, the gas mask was actually invented by a black man, and so some of the miners refused to use it because it was invented by a black man, until during World War I, the federal government decided they were going to use the gas mask, and at that point, more miners used it as well. But before the use of the gas mask, the miners used to take a little canary into the coal mines to alert them when the atmosphere in the mines was too toxic for not just the canary, but for the miners. And so when the canary started gasping for breath, that was a signal to the miners that they needed to leave the mine. And the metaphor, which is used throughout a book that I co-authored with Professor Gerald Torres called The Miner's Canary, the idea is that in the context of law school, it may be women are the canary. In the context of admission to the University of Texas, it may be that blacks and Latinos are the canary. But they're the canary in the sense that they're more vulnerable, but they are not the source of the problem. They are a signal of a problem, and the problem is located in the environment, not in the canary. So the goal is not to fix the canary, right? This is something that we try and do, right? Outfit the canary with a little pint-sized gas mask, so that it can withstand this toxic atmosphere. The idea is to use the signaling of the canary to fix the atmosphere in the mines, not only for the canary, but for the miners as well. And that's the answer that I really have to the other gentlemen who were on the panel with me at the Century Foundation, is that they keep thinking that the problem is somehow located in the canary and they just need to change the canary, right? So at one point it was blacks and Latinos who were the canary. Now we're going to have poor people of all colors as the canary. And I am not opposed to admitting any or all of these. It's just that none of these approaches are getting to the fundamental problem. The atmosphere in the university has been co-opted by a very business-oriented notion that the way in which the university succeeds in terms of its mission is to prepare people for the workplace. That's something David Labouré calls sort of social efficiency and social service. But what we're really missing in all of this is a conversation of the mission of higher education to prepare all of its participants for participation in a democracy. And participation in a democracy clearly includes being capable of supporting yourself and your family, but it also includes leadership in ways that are going to plow new ground for other people to come behind you and assume their responsibilities as citizens. But instead of looking at a mission-driven admissions policy, we look at an admissions policy that's driven primarily by test scores and quote-unquote the aptitude of individual students who apply. But when you think about these test scores, for example, the LSAT, I ended up doing research on that in terms of women at the University of Pennsylvania. The LSAT is a terrible predictor of performance in law school. This is the debate I was having with Rick Sanders, who thinks there's some mismatch when people don't do particularly well on the LSAT. Turns out the LSAT explains 14% of the variance in first-year law school grades. That means that 86% of the variance is not explained by the LSAT. It's a little better second year, 15% of the variance. And this is where Rick Sanders and these others are saying, well, the problem with blacks or with women is that they're not very smart or they're underprepared to take on law school or these other activities, and we can tell that because of their LSAT scores. Now, I'll stop talking, but I have to add one other thing, which is I was a lawyer working for the Legal Defense Fund throughout the South on issues of voting. And one of our challenges was to show that voting was racially polarized. And the way in which to show that voting was racially polarized is we would hire a political scientist or someone who was capable of running all of these numbers to show that if you knew the race of a voter, you could predict the race of the candidate that that person was likely to vote for as evidence of racially polarized voting. That was our claim. If we went into a courtroom and said, if you know the race of the voter, you can predict the race of the candidate they're going to choose 75% of the time or 80% of the time, the court would say, well, that's fine, but where's the other 10% or where's the other 20%? You haven't shown that it's perfect in terms of the correlation. So for me, to go from that level of expectation, you better show very strong correlations, to the LSAT explains 15% of the variance in first-year grades, and that's somehow a marker of who should be coming to law school, or the same thing with the SAT, which is normed based on the performance of upper-middle-class white students. So my point is, it's important to think about diversity and to bring people who've been excluded onto campus, but it's equally important to think about what is the mission of higher education and how are we failing to meet that mission in our preoccupation with trying to raise money for the university or trying to enhance our status on U.S. News and World Report.
Thank you for that. Just as a follow-up, and then I'll sit down and stop talking. Do you imagine the justices will take this case as an opportunity to go to where you just described, the conditions of the coal mine and so on? I think you maybe referred to that as an opportunity earlier on. And whether they go there or not, do you imagine the aftermath of however they rule may lead to this kind of a conversation about the conditions in the mine generally?
Well, you know, in the past, Justice Thomas has talked a little bit about standardized testing and in a way that I think reflects some nuance to his ideas about affirmative action, but I don't expect them, to delve into those issues of equity and merits in the way that Professor Guinier does. I don't expect that at all. That's something that needs to be done at the level of the university. And as I suggested, perhaps if there is a reduction or a limitation on the extent to which race-based affirmative action can be used in holistic review, perhaps there will be some further discussion of those issues, of the admissions process itself. And if that is a consequence of such a decision, then I would be very pleased.
Hi. So when you were speaking earlier, you were talking about how O'Connor's opinion left itself open. You said that it didn't look inward for the value of diversity, and you talked about how it didn't define critical mass, but it couldn't also because you can't use quotas. So my question is, currently, what is the legal definition of diversity that the courts are using, and how does this play out on college campuses, in your opinion?
Well, the criticism is that Justice O'Connor used the term critical mass. The terminology itself was ambiguous, at least from the perspective of those who critique it and who have used it as an opening to say that universities are really engaging in what is forbidden, which is the pursuit of particular numbers of minorities. I don't think that Justice O'Connor understood what she was saying in that way. And to speak to the second part of your question, what Justice O'Connor suggested was that universities can pursue underrepresented students to the extent that they are able to have meaningful representation on campus to achieve the benefits of diversity on campus, breaking down stereotypes, preparing people for living together, working together, those sorts of things. The further critique that I offered is that although I would embrace that conception of diversity, I think it's wonderful to have people from many different backgrounds in a classroom together, talking to each other. I think it makes conversation more vibrant. That's my experience in teaching. The critique is that we also should talk about discrimination and its effects, that in pursuing these admissions policies, affirmative action admissions policies, we are correcting for historical injustice. When we're talking about a state like Texas that has this history that Professor Guinier described, I think it's really important to come to terms with that history and to understand that history does impact students' conception of UT, the flagship university, students' sense of whether they should even apply, of whether they'll be welcome. I think the history matters.
Thank you. Thank you.
Good evening. All right, so it seems that there are two competing, I guess, somewhat parallel uses of admissions. First, to help a university decide which class they want to admit and how to shape that environment. The second one, which Professor Brown-Nagin discussed more explicitly, but you also discussed when discussing the history of UT's admissions policy, is an assessment on K-12 education and what people are actually bringing to the table when they apply. So my question is related to that. How efficient is affirmative action, and are there more efficient ways of accomplishing the goals that we're trying to seek, which is to have a more representative society, to enable more civic engagement? And toward that, do you think that Fisher, however this turns out, whether it narrows the use of affirmative action, whether it overturns Reuter, will force us to re-examine cases like San Antonio versus Rodriguez, also in Texas, that said that first, that education is not a fundamental right, which is very interesting, and second, that we can't use cross-district funding strategies, that you can use localized funding strategies, which we know are associated with racially discriminated housing patterns and also socioeconomic housing disparities.
Yes. I mean, we have so little time, it would take, I mean, my answer is actually no. Sound like Mitt Romney. I do think that we need to re-examine the role that the university is playing in the 21st century. I think that role is changing. I think that technology is pushing us to change, and that there are going to be many challenges facing the university in terms of the mission and the role that it plays in a 21st century high technology society. I don't think, however, that you can just look at affirmative action by class or affirmative action by race independent of what the university is doing more generally. And in particular, the way in which the university is preoccupied with the qualities of the students whom it admits rather than the career trajectory of the students whom it graduates. So we hear lots of bragging about the SAT scores and the LSAT scores and the GRE scores of the people that we are admitting to our university, as if somehow picking people who are obviously already very talented is, it takes away from us the responsibility of really teaching them because they're so talented they could teach themselves. So I think the mission of the university really needs to be put on the table and discussed seriously in terms of the 21st century challenges that we face, given the fact that many people will have access to university resources without being enrolled in universities based on the technology. And what does that mean? How does the university take care of the students or educate the students who are already here, and what is it educating them for? Is it educating them to simply get a good job so that they will make enough money so that they can then donate some of that money back to the university? Or is it actually about cultivating leaders who are going to change the world, not just for themselves, but for everyone else? And I think that's one of the reasons I think it's great to be here at the Ed School, because frankly, the Ed School seems to have a clearer sense of mission than many of the other institutions associated with Harvard.
One brief follow-up. I do think, I don't think that San Antonio versus Rodriguez is going to be reconsidered by the Supreme Court itself. As you may know, there are tons of school deseg cases that have been litigated in the state of Texas. School funding cases have been litigated in the state of Texas. There's continuing concern over the state of the schools. I do think that this case, to the extent that affirmative action is limited, will put pressure, greater pressure, on Texas to address what is a criticism of the Top 10% program, which is that some of the schools are not as strong as other schools. And thus some of the students who graduate in the top 10% of their high schools aren't as prepared as other students who are attending other high schools. Well, as I mentioned before, I think that's an indictment of the school system, right, of K through 12 education in Texas. And what one would hope is that if these percentage programs are the main avenue for achieving equity, and if there is concern about the student's experience and the quality of education, that there will be pressure to try to, for instance, break up racial concentrations, concentrations of students who are in poverty. Certainly the latter puts pressure on students, performance pressure. They don't do as well generally when you're in a school of concentrated poverty. So I hope it is a consequence of this case. That would be a good thing.
Thank you.
Professor Brown-Nagin, Professor Guinier. My name is Phil Lee, and my colleague Matt Shaw, who just asked that question, we are the co-chairs of Harvard Graduate School of Education Students for Diversity. We just want to thank you very much for coming out. I am thrilled about this new perspective in terms of analyzing equal protection cases. It seems to me there's been a shift in the 50s and 60s where cases like Brown talked about the irreparable damage, psychological damage to black children in segregated schools. Cases like Loving v. Virginia in 1967, where Chief Justice Warren, in the majority opinion, talked about miscegenation statutes are nothing but white supremacy, right? And then we have the Boskey case, 1978, that talks about diversity for diversity's sake. So we could celebrate diversity because we have vegetarians in the room, we have people that play golf, we have people that fish. According to the court's articulated rationale, this is consistent, right? But you, Professor Nagin, and Professor Guinier talk about, let's go back to social justice discourse, right? But as a practical matter, how do we move the court from, or educators or policymakers from diversity for diversity's sake back to tackling the vicious legacy of white supremacy and other forms of dehumanization?
That's a really tough question. I mean, because I think you'd have to change the composition of the court rather than simply inspire the court anew. Having said that, I do want to reference an article by Reva Siegel, who's a professor at Yale Law School, called The Case of the De Facto ERA, where she talks about the ways in which the Equal Rights Amendment was not passed and it did not become an amendment to the Constitution, but it was discussed, and it was discussed through a kind of public debate that elevated the consciousness of many Americans to the ways in which women were being discriminated against because of their gender. And Ruth Bader Ginsburg ended up litigating at least 3 cases during that period in which the Supreme Court started to interpret the cases as if the ERA had in fact been adopted. So, I mean, that's a long shot with this court, but it's always good to dream.
Well, I would suggest that the court is obviously important, and in terms of the court and its analysis, it's important to think in the long term as well as the short term. I think our energies are focused on Justice Kennedy, who has shown some sensitivity to, the need to integrate society. He talked about several different rationales for the integration of schools and parents involved, even though he didn't like the particular policy in Louisville and Seattle. I would also say to you, though, that the work that is done at the state and local level in legislatures, the work that's done in schools, quite apart from the courts, is just as important and maybe more important. And is these are the places where the groundwork is laid for later legal decisions, which is what Professor Guinier is saying. So the social justice imperative has to come from below. That script, that narrative, that urgency has to come from people in their communities. And we hope that later on, the Supreme Court, when it hears a case 20 years from now, will somehow be influenced by the energy from below, the laws that have been passed. That's the way that I think the change has to happen.
Thank you.
So a little more narrow of a question. A lot of the commentary, it seemed, around the oral arguments focused on the idea of this critical mass. And a lot of the commentary seemed to focus on both counsel for the government and counsel for Texas didn't seem to have a really great response to how you can have a critical mass without having some sort of quota system. But if the court doesn't want to overrule Reuter, it seems that the court is going to have to answer that. So what should have counsel for the government? What should have counsel for Texas? What could the court say to somehow uphold a critical mass standard, yet not reach into some sort of quota?
Well, I don't think the council could answer that question in any way other than what they did, which was to say there is no magic number. Texas does not, and this is unlike Michigan, does not actually review the numbers of underrepresented students who are admitted on a rolling basis. It seems entirely consistent with its practices that it doesn't look for a particular number of students. With the holistic review, obviously it's seeking to increase and to some degree the number of underrepresented students who are admitted if there are individuals who otherwise merit admission, if you follow what I'm saying. So I think that there's been so much discussion of quotas, and it's been so present in the court's precedents and in popular consciousness that it's hard, I think, to consider that one could have a holistic review program in which race may be a consideration, but there actually isn't a magic number.
Well, could I just add one thing, which is in terms of the holistic review, in 2008, which is the year that Abigail Fisher applied, the school had set aside 1,200 spaces for students who would come in based on holistic review. The holistic review had two paths. One was simply based on test scores. The other was based on a more holistic view of the student. Of the 1,200 students who were admitted pursuant to one or the other of the holistic review, there was 216 Black and Latino students. Of the 216 Black and Latino students, 183 came in just based on test scores. So we're talking about 33 Black and Latino students who were admitted based on some form of holistic review in a class that has 5,000 to 6,000 students, and in a university that has 45,000 students. And we're talking about 33, and whether the University of Texas should somehow be punished for admitting those 33 students, even though there's no evidence that they were admitted based on race at all, right? The only evidence is that for holistic review, you have to fill out a form in which you are asked to identify yourself based on race or ethnicity. But you're also free to say none of the above. So again, race was not driving the decision-making at the University of Texas, even after it introduced the holistic review in addition to the top 10% plan.
Thank you.
Hi, good evening. I really enjoyed your talk this evening, and I'm curious more on like the legal theory and the lack of imagination in the United States for proportional representation. I'm thinking about the way that we are now exporting democracies around the world, and when we counsel countries to develop democratic governments, we encourage coalition building so that there is a proportional representation of all the dynamic ethnicities and regional regional preferences. And how close are we in this country, if you will, from your like legal colleagues and scholars, to actually, ridding ourselves of like quota? I don't believe is a dirty word, because in terms of like a parliamentarian democracy that most of the Western world uses, they actually do that all the time. There's also some kind of like connection why we may not believe in this is to this like myth of meritocracy. Like, you race hard, you work hard, you get across the finish line first, therefore, to the winners go the spoils. Where could I look in some legal theory that's going on right now to like push our country, because we're gonna need something, because it's no longer, I don't know if we're suited to do this two-party system where at the founding in the Constitution, yeah, it looks like we have some, the Tories and the Whigs, and say, we're gonna go between those two. But now we have like a very dynamic democracy that I don't think there's anything wrong with like demanding that every region from the country, every race, ethnicity, has a proportional representation at all levels of our democracy. Where could I search, or have we heard in the United States about that? Yeah.
Look no further.
Well, I think you're right that we're still in 1789. The rest of the world has taken off and left us behind, right? This is, if John F. Kennedy said he wanted to have a man on the moon, and we did. If we put our energies behind it, I think it's possible to have a more invigorated, robust democracy. The place I would send you is a place called Fair Vote. It's in Maryland, and you could ask for Rob Ritchie. He's the person who directs it, and they can give you all kinds of data about the different voting approaches that are used internationally, and then compare that to the US, which is really way behind. I mean, think about Germany, which has a system of representation that's much more egalitarian, and we made them do it, right? Right after World War II. It's like we were able to get them to do it, but we simply can't look at ourselves and make any changes because we're already so perfect.
Yes. Thank you.
Thank you.
Excuse me, I have just one quick question.
I'll stand here, please.
I'm really curious about this question, really short question, but in the oral arguments, did any of the attorneys address or discuss the issues in regards to the reliability of merit? And for example, someone that, not just in regards to the outcome, but in regards to access. So someone that pays for an expensive LSAT class or expensive SAT tutors, and I know that happens a lot in private schools or depending on the class, middle, upper class, and those are proven to raise your test scores. So did in the oral arguments, did anyone address that in regards to like the merit of the reliability of the merit system?
No, not at all.
But I recommend Crazy You by Andrew Ferguson. He actually goes to look to find out who it is that's making up these various rankings of schools based on the SAT or LSAT scores of their students. And he's wandering around this building and he can't find, there's like one person for U.S. News and World Report who's creating all of these rankings for all of these universities all over the country. It's absurd. If you want to read it for yourself, I recommend Andrew Ferguson, Crazy You.
So let me thank you all for coming out tonight. You were a very attentive group and your questions were superb. Let me particularly thank our panelists for what I thought was a provocative, interesting, and engaging conversation. I am very much looking forward to see your reaction to what the court says sometime between now and June. And again, thank you very much for coming out and joining us tonight.
Thank you. Could I make one announcement? I also want to thank Julie Rubin, who is...
Yeah, is she here?
Yes.
Oh.
Whom I have never met,
Hi, Julie.
but who helped us write this brief, and without which we would not have made our deadline.
Yes, thank you, Julie.